Hello everyone, this is Shiv Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. So in the today's session, I will be dealing with the doctrine of severability. This topic will also be covered in two parts. In the first video, I will be dealing with the introduction section and then further I will go through the practice of doctrine of severability. And further in the next video, I will be dealing with whether one could challenge the constitutionality of a law or not, and then further the presumptions taken by the court, and for thereafter at last I will be dealing with some effects when a law is declared as unconstitutional. So let us start this video with the doctrine of severability, as this doctrine is also known as the doctrine of separability. The word, to the extent of the inconsistency or contravention, makes it clear that when some of the provision of a statute become unconstitutional on account of inconsistency with fundamental rights, only to be repugnant provision of law in question shall be treated by the courts as void, and not the whole statute. The doctrine of severability means that when some particular provisions of a statute offend or is against a constitutional limitation, but that provision is severable from the rest of the statute, only that offending provision will be declared as void by the court and not the entire statute. The doctrine of severability says that if good and bad provisions are joined together by using the word and or, and the enforcement of good provision is not made dependent on the enforcement of the bad one, that is, the good provision can be enforced even if the bad one cannot or had not existed. The two provisions are severable and the good one will be upheld as a valid and given effect to. On the other hand, if there is one provision which is capable of being used for a legal purpose as well as for an illegal one, it is invalid and cannot be allowed to be used even for the legal purpose. In this doctrine, it is not the whole act which is held invalid for being inconsistent with the part 3 of the Constitution, which is given to the citizens of India. It is only those parts that are inconsistent which are violative of fundamental rights, but just the part which violates the fundamental rights is separable from that which does not isolate them. If it is there that the valid portion is combined with the invalid portion, that is impossible to separate them. Then in such cases, the court will leave it and declare the whole act as void. This process of doing is known as the doctrine of severability. Now let us see the practice of doctrines of severability. It has been in practice for a very long period of time and it is not a new thing. It has been adopted in many countries like the United Kingdom, Australia, United States of America, Malaysia, and so as well in our country, which is India. In England, UK, the doctrine of severability goes back to when it had originated in the case of no defendant versus Maxis Nordenfeld Guns and the company limited. In this case, then in their country, in the other countries like the United States of America, where the first case of doctrine of severability was decided in the year 1876. After this, a question evolved which asked if the Congress knew about the invalid portion had it enacted it the first time. In this particular case, the case was centered around the 15th Amendment of the American Constitution that spoke about the voting rights not being denied to the American male citizen on the basis of color or race, etc. The doctrine of severability has not been just a part of the Western world, but also has spread to the eastern countries of the world, like from India to Malaysia. And in Malaysia, this doctrine was evolved in the very popular case, which is Malaysian bar and another versus government of Malaysia. When we talk about the India with respect to the doctrine of severability, then we need to study and understand how Article 13 of the Indian Constitution came into being, came into force. This doctrine works when it becomes evident that any part of the law offends the Constitution. When we talk about the in context of the Indian Constitution, then it will be the fundamental rights which are guaranteed by the Constitution. So this doctrine will work especially when it is subjected to this part, which is part 3 of the Indian Constitution. That's all for now. Let us meet in the other section where I will be dealing with the further the new topics of this particular topic, that is doctrine of severability. Please do like and subscribe the channel. Thank you.